in the Honorable High Court at Calcutta in connection with publication of the panel in the website, as the candidate who participated in the selection process could only see his own result in the panel by inserting his roll number and date of birth. But he was not in a position to know his own rank vis-a-vis rank of other candidates from the panel. The publication of panel in the website of the Central Commission was not in accordance with the provisions of Rule 14, bracket 15 of the West Bengal's selection rules. His Lordship, the Honorable Justice Bikash Bhattacharya, disposed of the said petition by directing the Central Commission to publish the entire panel in terms of rules within a period of 1 week from the date of the order. Since the Central Commission did not comply with the direction of the Honorable High Court, a contempt application was moved, and ultimately the Central Commission published the entire panel in the website on June 20th. After about 1 month from expiry of the panel, the chairman of the Central Commission issued a notification declaring expiry of the validity of the panel for selection of Group D post with effect from May 4, 2019. With the above factual matrix, 4 unsuccessful candidates, including so-and-so, filed a petition, praying inter alia for direction upon the chairman of the commission and the chairpersons of 5 regional service commissions to fill up the residual 108 vacancies of Group D by counseling. I'm just skipping over, then just down below, 3 lines below. By supplementary filing affidavit petitions brought to the notice of the High Court, names of 523 candidates who got appointment in Group D post by the President of West Bengal Board on the basis of recommendations made by the Chairperson Regional Commission after expiry of the panel on May 4, 2019. In course of hearing of the said petition, the Central Commission and all the regional commissions took the stand that the chairpersons of the commission did not make any recommendation, what is this, for appointment in Group D post in schools after expiry of the panel. On the other hand, the board filed an affidavit disclosing the original recommendation letters under the signature of the chairpersons of the regional commission after the expiry of the panel on May 4, 2019, on the basis of which appointment letters were issued by the president of the board to all those candidates after expiry of the panel. The appointments of more than 500 candidates in Group D post on the basis of recommendation of the expiry of the panel may so and so, coupled with the contradictory stand taken by the board and the Central Commission, as well as the Regional Commission, led the Honorable Court to observe in the order that corruption writ large in the whole process of the public employment and directed CBI to conduct an inquiry into the extreme illegality in making recommendation and appointment to the undeserving candidates in Group D post. The order dated so-and-so passed by the Honorable Court was challenged before the division bench by performing force. The single bench directed the CBI to conduct an inquiry to identify the miscreants who issued letters of recommendation in order to secure appointments of undeserving candidates in Group D post. Was not found favor of the honorable judges of the division bench in High Court. On December 6, the Justice so-and-so disposed of all the appeals by taking the decision to conduct an inquiry to reveal the truth in connection with illegal and or irregular appointments made in Group D post by constituting special team to be monitored by a retired judge of the High Court. The honorable judges of the division bench modified the direction given by a single judge to secure equal opportunity to successful and deserving candidates for appointment in Group D post by revealing the truth and by fixing up the responsibility for the misdeeds of giving a recommendation and appointment in Group D post in an illegal manner. Since the inquiry committee could not submit the report, the completion of inquiry within time, these are procedural aspects, I am not talking my lords.
51.
Then kindly turn to
Page.
paragraph page.
Page 470.
Kindly come to paragraph 6.1.
Page 475.
471 এ চলে আসো
470.
Paragraph 6.7 of the
Page 2.
judgment,
page 470
maybe page 471.
Yes.
Result of illegal procedure adopted by the Central Commission, the Regional Commission, the Board. In view of the illegal procedure adopted by the Central Commission, the Regional Commission, and the Board, 609 unsuccessful candidates got false recommendation letters from the Office of the Central Commission, which were prepared by using fictitious memo of the Regional Commission. These are all findings of Justice Bar. Fixing scanned signatures of the chairpersons of the Regional Commission by keeping them in the dark after the expiry of the panel on May 4, 2019. The said 609 unsuccessful candidates who obtained false recommendations from the Central Commission also received appointment letters based on the false recommendation from the new building of the Central Commission situated near Anandalok Hospital. We have annexed the names of 609 candidates, their father's name, district, region, name, school, so and so, by the president of the board by preparing a format which is annexed to the report and marked with annexure. We have made analysis of the information collected from the Central Commission and the board and found that names of 318 candidates who got false recommendation, even when their names did not appear either in the panel or in the waiting list. The names of 318 candidates, their father's name, full address, so and so, and date of recommendation letter and date of appointment issued by the board who got false recommendation appointment was even when their names did not appear either in the panel or in the waiting list next to them. But this massive corruption practiced by state authorities. Then that I'm just skipping over.
483.
Kindly come to paragraph
4.7. 4.7.
Kindly come to fixing of responsibility.
Paragraph 7.
এখান থেকে দেখা তো
স্যার একটু এই পেজ 483
ওটা পেজ 483
স্যার
Yes, please.
সেই সব না দিকে গেলাম
483. The group.
Now kindly turn to me, Lord, page 483.
Volume
Yes.
4.7.
4.7. Result of illegal procedure adopted by the Central Commission, the Regional Commission and the Board in view of the illegal procedure adopted by the Central Commission, Regional Commission and the Board. 381 unsuccessful candidates got recommendations from Group C post after expiry of the panel, though those candidates did not qualify for being considered
This
within.
is the
Same.
fixed figure. This is a fixed figure.
No, these are all illustrative.
Initiation.
But these are all, as I say, is illustrative. Nobody can, even the School Service Commission, till the last date of hearing, come up and identify that these are the figures which we stick by. I placed before Lordship, they say identified so far. There are other areas manipulation also, giving deliberately false marks in violation of statutory provision. And appointments given in excess of vacancies. All these things are there. Ultimately, when the CBI conducted in, they have secured some OMR sheets, and the entire argument before the High Court was that you cannot look into those OMR sheets. None has argued, with the best of respect and stand to be corrected, that we are genuinely candidate. We have nothing to do with this. Please segregate us. I don't find from the entire judgment, which was so elaborately written by the Honorable Judge, taking all pains. Therefore, there was no scope for any segregation. And now, my Lord, I will just invite my Lord's attention. I was shocked how this selection was made to NISA. This is also well planned. So kindly turn to page 1264,
Volume 5.
volume 5B.
Yes.
Now page 1262.
Yes.
what you will kindly note, two important state organizations like Saraswati Press and Shilpo Bhatta, government organization. They were initially knocked out. On what ground? That they have only given the quotation for 1 and 2. And
They are giving contribution.
and the rest are, you will kindly see the rate quoted. So for the A, B, C is concerned, only difference 9,000, 8,500, 8,000. All 500 rupees difference. And this was handed over on the very same day when this was opened. The issue for tender was designing and printing OMR, scanning and preparation of results, consolidated transporting costs, and so. Therefore, basic work was designing and printing and scanning and preparation of results. Then kindly come to the next page. Then kindly sees at page 1264, from the chairman to the vice president of NISA, date is 1st of December 2016. Subject is scanning of AMR and processing of result, both secondary, higher secondary examination. Work order being issued. Dated 24th of October 2016. With reference to above, you are requested to start scanning of AMR sheets of both secondary, higher secondary, and process result of the same in due process. This is received at the very same office on the very same date by Ajoy Shah, some Shah, who is representative of NISA. How could he be there on the date when this notice was issued? And the address of NISA is Noida. How could the gentleman know that this day will be open? This is all pre-planned. And then next page. This is 29th of March 2017. Subject of scanning of AMR and processing of result in connection with third SLST. What are the work assigned? Scanning and processing of results, refund of AMR sheet after completion of the process, handing over of scanned images of AMR record of results, the other information soft copy mode with the clarification. Therefore, these AMR copies, scanned images were handed over. Where is that gone? And then 1267. 7 September 2017. Some additional work is assigned to them without having invited them to participate in any tender process. And that again on 7th of September, the Ajoy Shah was in office and receives this. And the nature of job awarded was understand for finalization of typing schedule. The work includes arrangement of venue, conduct of type test, evaluation of paper, handing over result. Therefore, all these things taken in a basket, it would be apparent without any out of doubt that this was done with now.
List of persons appointed after next year. You can see.
Now kindly take the trouble to turn to paragraph 271 of the judgment. This is very important. at page 228. Rather, I would be prompted and tempted to read from paragraph 262.
Page number?
Page 227 or 219 of the input judgment. Paragraph 269. The SSC board and state government have consistently stonewalled any queries with regard to the selection process and have not come clean with regard to the manipulation and illegalities involved. Conduct of three authorities during the course of hearing can be classified as anything other than being cooperative. The Secretary of SSC has submitted a statistical report with regard to the illegalities in the appointment in the respect to the four categories by a signed report dated March 6, 2024, to which we have alluded to herein. In course of hearing, SSC, in response to queries of the court, has submitted details of the recommendations made by SSC in respect to the four categories and number of appointment letters issued by the board in respect to the four categories. Significantly, SSC had recommended 11,425 candidates for appointment post of assistant teachers for class 10, whereas board succeeded in generating 12,946 appointment letters, thereby issuing 1,539 excess appointment letters. Now, who is going to identify them? Then the board has entitled to similarly in respect to assistant teachers for class 11 and 12. The board had 5,756 appointment letters as against recommendation of 557 candidates by SSC, thereby issuing 199 excess appointment letters than entitled to. In respect of Group D, board has issued 4,550 appointment letters against a recommendation of 381, thereby generating 669 excess appointment. In respect of Group C, board has generated so and so, thereby generating 416 excess appointment. Justification that has been sought to be preferred by board is that all appointment letters were on the basis of the recommendation of SSC. SSC has contradicted such justification of board by claiming that no such recommendation letters were issued. Board has no authority to issue appointment letters unless such candidates is recommended by SSC. In four categories involved, there have been appointments far in excess of the recommendations. There have been manipulations, illegalities in the recommendation also. SSC at no stage of hearing claimed that it was able to check all the records and be definite so as to the number of illegalities in recommendations made, but had limited itself to those figures as stated in the paragraphs above. In fact, reports in the form of affidavit filed by SSC from time to time had always stated that they discovered the illegalities as were brought to their notice by the litigants or on order of court. The SSC had proceeded to withdraw cancel recommendations in favor of candidates participating in the four categories on the basis that there were manipulations in obtaining recommendation. SSC had accepted the data found in the hard disk seized from ex-employee NISA, Bikash Bansal by CBI. Then kindly turn to paragraph 288.
Two 98.
288. None of the Article 12.
Yes.
None of the Article 12 authorities had ever disputed the genuineness, veracity, authenticity, and legality of the data contained in 3 hard disks seized by CBI from Mr. Bikash Bansal at any material point of time. SSC had accepted such data acted upon, found manipulations, illegalities, machines, proceeded on basis of such findings and withdrew cancelled recommendation of various candidates. It had utilized such data to arrive at a finding that OMR sheets had been manipulated, and the marks obtained by candidates stored in the server were considerably higher than the marks which such candidates could have received. On a thorough and proper evaluation of the OMR sheets of such individual candidates found in the hard disk seized by CBI. The third hard disk seized by CBI had been produced in court. CBI had granted inspection of documents downloaded from such hard disk to persons seeking such inspection pursuant to orders of this bench. None of the persons taking inspection have contended that the OMR sheets are not theirs. The OMR sheet bear a unique barcode, and I've already spoken about this. Therefore, this is the wholesome figure of an illegalities committed. And I don't have to do that.
But their contention is OMR sheets under the rules have to be only maintained for an year.
But the decision was they will destroy it, keeping mirage copy. That is the decision of the SSC. That affidavit I have placed with Lashmarkota.
So the mirror copy was there, but there is discrepancy in the mirror copy.
Mirror copy was not there.
There,
Mirror copy was also not kept. That is the whole game.
no, they gave it to somebody else to do it. They kept it on their server or their computer rather than the system.
SSC storage, it was not there at their own admission. And the CBI also did not find the mirror copies from the SSC server.
Decision was taken.
But the specific decision, as I have referred to, Lordship, kindly turn to page 2901 of volume 5. It was the decision. I just read out once again loudly. It is stated that the chairman of the commission, in his executive capacity after the expiry of 1 year in absence of rules, issued executive instructions by letter dated 22nd July 19, directing that the answer scripts, OMRs, and other papers related to the disposal and destroyed as the period of preservation of the same had already expired. The same was to be destroyed after scanning in digital form and creating mirror image. That's the norm. The physical image is destroyed to get rid of the space. But there is no lack of space in space.
2023 Supreme Court.
Records.
And this was the affidavit filed before the Supreme Court by an affidavit on 16th of March 2023.
টেন্ডারেও বলছে ওদেরকে প্রিজার্ভ করতে
Now that since the law is well settled, I really would like to bring one judgment to your Lordship notice, where the Supreme Court has said if there's any out of doubt, then the entire thing should be cancelled. And the Honorable Court directed to do it afresh. What's the harmony?
Fresh means everybody has to study again. So,
They are all,
just exercise.
some trouble has to be taken.
Among the candidates.
But this is only for the selection amongst the candidates who had appeared, not from the outsiders.
So it's only for those candidates who had appeared,
Yes,
not for any outsider.
not outsiders. But it will be pushed back to 2016 situation. Who are the candidates? They will appear, and the age bar will be condoned.
Look, if that examination is being held today, there's no question of age bar.
That's not. Even if somebody has expressed their doubt in mind that age bar would come in, it will not come in. Now that
It's not meant, it will not be a fresh advertisement.
no,
It's only confined to those who
only
have.
confined to the participants who had participated. Now that I was not tempted to cite this judgment, Tanvi Sarwal, but CBSE, this is 2015, volume 6 Supreme Court cases,
573.
2015,
volume 6,
page number.
573. But the relevant paragraph, I just cite. Reading from paragraph 20, as would be available from the status report.
Yes.
As would be available from the status report, out of 123 solved answers on particular code and retrieved from the mobile set of one of the persons arrested. 102 answers were found correct in a comparison with the answer key provided by CA. As referred to here in above, 358 mobile numbers had been pressed into service and at least 300 vestly fitted with electronic devices have been used. Having regard to the uncompromising essentiality of a blemishless process of examination involving public participation, we have no alternative but to hold that the examination involved suffers from an infraction of its expected requirement of authenticity and credence. We are conscious of the fact that every examination being conducted by a human agency is likely to suffer from some shortcomings, but deliberate inroads into its framework of magnitude and the nature, as exhibited in the present case, demonstrate a deep-seated and pervasive impact, which ought not to be disregarded or glossed over, lest it may amount to travesty of a proclaimed mechanism to impartially judge the comparative merit of the candidates partaking therein. If such an examination is saved, merit would be a causality generating a sense of
OMR sheets are available. Scan sheets are available. That can be reassessed.
one way of looking at it. So, but at the same time, investigation is carried out when the allotment of academic marks and to give benefit to the persons who have paid money, the alteration of their personal test marks. These are all serious allegations are there.
No, there are two ways. Is
Wait
there
about-
any finding? Is there any finding recorded that the OMR sheets? Is there are two OMR sheets we have?
No.
No, scan copies two are available. There's several or two.
Page 11.
Scan copies available, according to us, not in the website of the SSC.
This page 1131, what you showed us.
Anyway, that
every
one,
OMRs are
they
there.
supply, they now say this is from the CBI report. That's the explanation given for the court.
No. That's something separate. There are two OMR scanned copies of OMR sheets. Both of them can be compared to know whether there's any violation.
No, there is no two copy.
One
Now, that the
one copy given by the CBI.
Marking it can do what he wants.
only one copy which is seized by the CBI, nothing else.
No, there are two copies available.
Scan ticket.
There's only one.
Everyone.
No, Pankaj Bansal and the other person also had.
Oh, Pankaj, yes, same. Same.
But nice and
No, there are two. I thought there are two sets of OMRs.
Two sets up there, from two agencies, and the same.
Pankaj Bansal has one. Where is the other one?
nice and scan.
Nisa had it.
Data scan tag.
Data.
It's a data scanner. That's a
Therefore, whatever CBI has seized, that is there.
What's there is both CBI and have examined them and have segregated.
No, I didn't. No, there are two sets available. Are the two sets matching or not matching? The two sets, as per them, were matching.
That's much it.
On the authenticity of that itself, because the marks which have been allotted are not in seriatim with the OMR sheets. But they were marks to be allotted on account of academic score also.
Yes, I'm sure that.
The rules, I will place the rules. Rules prescribes, first of all, academic qualification, then OMR.
Please allow us.
Academic
rules to follow.
Oh, that's what I think.
Sir, आपनी बोलूं sir, आपनी बोलूं rules to follow sir.
Pardon?
Sir, rules follow sir.
As per the rules, of the merit, is the academic marks, is the OMR sheet, and finally the lordship's the verification. So when all these three are added, the percentage which is given to my academic record, your lordships, I'll just read the rule, is about 40%. So if I know that I have scored 98% in my qualifying exam, your lordships, even if I do badly in my OMR, I would still have higher marks. I'll come to all that, your lordships. I'll show to your lordships that aspect.
No.
958 is 958.
May I complete?
Yes, yes.
Now, Lordship now kindly takes up the rules. What we are trying to
Blue 5 ball.
and confused. Volume 5B. These are statutory rules.
Yes.
I'm just placing the relevant portion. The Central Commission shall arrange written examinations. The Commission shall determine the method of written examination, contents of papers, so and so. Then, after the evaluation of OMR sheets of the written examination, the Central shall prepare and publish in their website all details of the candidates to be called for personality test category-wise on the
Okay,
basis.
now, first the OMR sheet result is declared.
Yes,
The OMR sheet result is declared.
on the basis personality test.
No. On the basis of the scanning done, after evaluation of the OMR sheet or answer sheet and the written examination, shall prepare and publish on the website the details of candidates who have been called for personality test.
Right.
Now, therefore, all the results of the OMR sheet were already declared then.
So your lordship, they were
Not clear, but
that was one of the orders that
Is
the
it?
High Court made, and consistently they did not.
This was not done.
Not done. That caused, that triggered the litigations.
This was not done.
No. Only after the Honorable High Court intervened, directed, then some marks were disclosed.
in the year
No,
2000.
this was not done. This was not followed.
No, your lordship.
In the year 2022.
That's why the direction was given.
I'm asking him.
Yeah.
Now kindly come to the relevant rule.
It was done before the interview or after the interview?
Before the interview.
No,
No, publication was done before the interview or after the interview?
Application never done. When it was challenged before the High Court, then on direction of the High Court, it was done after everything was complete appointment.
After the completion of appointment.
And after giving appointment.
2022,
It was done in 2022.
June 2022.
Now kindly come to know the relevant definition of interview list.
Was it disposed of within a year or after the year?
The petition.
Yes.
The petition was still pending, many issues.
You read out.
Direction was given by the High Court to publish the result, OMR result. When was that petition filed?
In 2021,
And when was the result declared?
2022,
22,
June 2022.
22. Cheat code about
How can that be? You said it's after the declaration of result that the marks obtained in the OMR sheet were declared. Correct? You just now said that.
Probably I am not able to communicate. But the OMR sheets were never disclosed. Marks were
Correct. You said the marks obtained in the OMR sheet, contrary to clause number 6, were declared pursuant to direction given in a writ petition after the final results had been declared. Correct? I asked you when was that writ petition filed? You said 2021. When were the results declared? You said 2022.
Dates are confusing.
Results declared in 2018.
But the
Results were declared in 2018.
2018,
When was the writ petition filed?
2021. 2021 it was filed, that's what 2018. When you come to know, then you challenge. Now that
No, the first writ petition for declaration of the results, for the declaration of the OMR results was filed in 2021.
now it was filed seeking the details of that, the merit standing, what marks were to obtain as per the rules. That was the writ petition. Now kindly turn to definition clause 2E. Interview list means a list of candidates to be called for Rule 2, Sub-Rule E, page 1998. Very confused.
Yes.
Interview list means a list of candidates to be called for personality test, category-wise on the basis of merit, that is marks of written test, academic and professional qualifications. Therefore, the academic marks and professional qualification is also very important for calling for interview. Then panel. I am not troubling my lot with the panel. So kindly come to Rule 12.
Page number?
The page is 2001.
Yes.
Selection of candidates and preparation of panel. The Central Commission shall arrange for proper custody of all online applications which may be received by its against the vacancies. The Central Commission, after receiving, I'm not troubling with that. Then 4, the Central Commission shall determine the method of written examination, contents of papers, duration of examination, time and venue of examination, and other matters. Here, the Central Commission delegated everything to NISA. Statutory obligation was the Central Commission should do it, they did not do it.
Yes, Padre. Oh, this may not be violated. This may not be really violated. This is only the method they had to determine. This may not be violated.
Yes, well, I'm just making my submission, also consider this. Then, after the evaluation of OMR sheet or answer sheet of the written examination, the Central Commission shall prepare and publish in their website with all details of the candidates to be called for personality test, category wise on the basis of merit in the ratio of 1:1.4. This was not done, and violation of this ultimately triggered the writ petitions.
2008. What published?
When was this writ petition filed?
2008.
This writ petition was filed in 2021.
Not in 18.
No, no, they didn't know this.
You didn't know it because the merit list was never published.
Never published.
So there were letters which were sent.
But when we find that somebody got appointment, we wanted to inquire, how could he get appointment? Because I know him better than that. I was never worse than him. Then ultimately these petitions came and kindly come to page 2008.
So complete. They were published.
What was published, I'm showing your lordship. Kindly turn to 2008.
Yes.
Your lordship will not find what are the merit position, what are the marks obtained, nothing, all vague.
The weight listed was published.
Wait listed, merit list, everything without giving the details of it. As per the rules.
When was this published?
No, this was published in 2018.
No, but the merit list was not published. The weight list was published.
This is not the merit list.
W1 means what?
Waiting list 1.
So what? No, the ones who had been appointed, their list was never published. No, was the list of the candidates who were selected published?
Yes, it was published 2018.
Where is that? Where is that?
Without giving
Which
the detailed
page?
marks.
Which page?
That is annexed Karachi.
Not been annexed, not in annexed.
No, this is not a part of this. Then again,
Where is that list of the students or the candidates who were selected published? When was that published and where is that list?
that list commission can disclose, but we don't have copy.
You don't have copy.
हमारे बोलते हैं, हमारा जो है, सुनो ना, ठीक हो तो
So
কথা শুনে
20th
instruction.
of August
No, but that-
2018, a list of selected candidates was
কথা বলতে না.
August 2018.
August 2018.
Final preliminary result was 10th of September 2000.
And appointments were made thereafter.
Graduate कर दी गई.
Yes.
Now the page 2020, there is a list. This was published pursuant to order of the court. So it says compliance of the order of WPS so of class 9 and 10.
Here the marks were disclosed.
This is for the first time marks are disclosed after the order. And this was disclosed in 2022. वो चारजन जो चार भाई पता होगा ना मामला को जाए
Okay.
নিজেরা কনফিউজ করছে আমার
This is volume 5B.
Yes, please.
Now kindly come to the rules. That is very important. So what got it?
2000 है 2001.
Without marks.
Without detailed marks. Without detailing marks, we have published, marks was published after the court order. Now kindly come to the rule 12 once again. Rule 12, sub rule 6.
You have read that?
No, I'm not sub rule 6, probably I did not read.
Rule 12, sub rule 6 you read.
Yes.
With all detail.
Therefore, we thought the requirement was to publish with all details of the candidates. This having not been done, then these petitions were ultimately coming to court for seeking disclosure.
No, if you read
17, 18 publication, they are not showing us.
2000, if you look at sub-rule A, it says Central Commission shall prepare and publish their website a merit list based on panel of candidates, category-wise of the merits list equal to the number of vacancies and region-wise list on the basis of option exercised by the candidate.
This is final list.
And
After
prepare and publish on the website category-wise list, waiting list on the details. It doesn't talk about publication of marks, but what is 6 does, and that list is to be published before the academic or professional qualifications are final.
This is a merit panel.
After final suitable.
There are two stages, different stages. 6 is prior to interview, 8 is after interview, and all details are the requirement of law. Anyway, that chapter is over. It was published at the order of the court, and then this.
This list which was published as per this 12.6, none of you are showing us. This 12.6 merit publication according to Mr.
It was not published. It was not.
Which page is it?
No. What was published was the merit list after the
Yes.
after academic evaluation.
Where is it? Which page is it?
No, that's not the point. Let's be very clear. Merit list was not published. The list in terms of clause 6, sub-rule 6 was not published, giving the details of marks of each and every student. No, that did not happen. No, read rule 6 is very clear. No. 12.6 is very clear. The evaluation of OMR sheets or answer sheets in the written examination. After evaluation of the OMR sheets or answer sheets in the written examination, the Central Commission will prepare and publish in their website all details of candidates to be called for personality test, interview list, categorized on the basis of merit, marks, academic, so and so, in the ratio of 1:1.4. No, with
So Joydeep Gupta, why don't you show us what you published?
Yes.
Which page is the publication that you came out with in terms of Rule 12.6?
you must have got, please, you must have taken a print out of that. Which page is it? Or is there none? What you are saying is you could go and look at your marks individually. That's not what. Where is that?
Had it been so, there was no question of litigation before the court.
First order would have been.
Yes.
We are asking you which page is that list. Can we have that? Okay.
Page created.
No, therefore, the court not being satisfied that the state government's involvement was very questionable, directed that CBI should also inquire into the matter. What prompted the state to create so much supernumerary post has a different meaning. I am not going to argue on this. They wanted to diffuse the grievances of the people who are standing in the road. We give you appointment. And an application before the court that we are giving appointment to secure that the persons who have been given illegal appointment, specifically mentioned, do not lose their job. Why? State government will here before constitutional article 14 was stares at our face. Transparency and non-arbitrary is fundamental principle of our jurisprudence. In that background, where I do not take much of your time, my submissions I conclude saying that the entire selection process has been vitiated.
Okay.
There is no
Next, please.
investigation, and let it be done afresh. Deeply obliged.
You want to go?
Only about 3-4
Now,
paragraphs.
just now, tell us in brief why the entire selection process is vitiated. It's impossible to segregate and find out the ones candidates who are meritorious
Yes,
with those who are not meritorious. Please come on.
my lord, the High Court, my lord, has given reasons, my lord, why it cannot be
So
segregated.
please do it in your own words. High Court reasons we know.
I can only read those paragraphs, my lord, of the High Court, my lord. Your lordship may kindly see, my lord.
See one example, page 59. What do you think? Edit this.
Page 59. Yes.
Edit this for first case counseling. Class level 11, 12.
Yes.
Again, no marks in this.
No marks.
No marks.
No, there are no marks.
This is for first stage counseling means that is where the academic results will be examined.
No marks is given.
No, marks are not. You are right. Marks are not given.
But the marks are all on the website, right? So each part, if anybody wants to investigate, they could have. But we have individual one is just
It is given. Always show
But the
there.
marks are not there. The requirement of the rule, my lord, is publication. My lord.
Page number 82, 1
Lord, that no marks are given.
1 to 1.
Page 1-2. Page 82, my lord.
No mark was given. Even 1 to 1 mark was not given. Page 1 to 1 mark was given. Candidate, particular candidate.
One communication, my lord, page 82, my lord. Volume 5B.
Why is the marks?
Marks, my lord, are conspicuously absent. No marks.
No marks.
So where are the marks?
Where is the marks?
Where are the marks?
Marks are not there. Their contention is marks are not required under the rule, sub rule 6.
But if your lordship may kindly see, my lord, that, my lord, it was an ongoing process, my lord, of, my lord, illegalities being detected, my lord. If your lordship may kindly see a paragraph, my lord, paragraph 242, my lord, of the impugned judgment, my lord. This is the stand of the SSC, my lord. So, my lord, it was, my lord, time and again brought to the notice by way of affidavits, my lord. The first line itself, my lord. In course of hearing, SSC did
Paragraph?
not discount.
Paragraph or
Paragraph
page number?
242.
Paragraph 2. Paragraph 240.
Paragraph 242, my lord.
213. Yes.
But in course of hearing, my lord, the SSC did not discount the fact that possibilities of further illegalities exist. So they are not certain even, my lord, on the date of passing of the order, my lord, as to the number of illegalities, my lord. Then your lordship may kindly see, my lord, page 260, paragraph 265, my lord. The court, my lord, is court, my lord, between, my lord, the state and the board and the SCC. It's a strange stranglehold on the court. Your lordship may kindly see, my lord, page 265. This is, my lord, a state is supposed to be a model employer.
Yes.
Paragraph 265, my lord, beginning inferences from the role of Article 12 authorities. The inferences, my lord, if I may read, my lord.
Yes.
In fact, a paragraph before that, the stand taken by the Chief Secretary. These are very harsh words, my lord. The court was compelled to use, my lord. Paragraph 264, my lord. The obdurate attitude of the Chief Secretary has to yield to his obligation to uphold the rule of law. They were all along, my lord. There are a number of words, my lord, the learned judges use, my lord, as to how they are trying to play ducks and drakes. I can, my lord, highlight, my lord, in a one-page, my lord, note as to how, my lord, these three authorities, my lord, have tried to mislead the court in three different directions. Your lordship may kindly see the para I, my lord, wished your lordship to read, my lord, para 265. The state government, therefore, has accepted that there were widespread illegalities in the selection process and that the number of persons who received appointments illegally could not be determined with exactitude. So 242, my lord, has to be read, my lord, with 265. And then, my lord, they go one step further. Now, my lord, you detect the illegalities and you perpetuate them. The next line is very important. They had resolved to create supernumerary posts to accommodate the illegal appointees.
Just one thing we'd like to know. Paragraph 265. As far as the state government and the SSC is concerned, you accept that statement of fact?
SCC at least.
1 minute, please.
Yes.
SSC, because this is on the basis of what has been stated. Be careful that you don't make a wrong statement. Just be careful you don't make a wrong statement, because if it was so stated before the High Court, it must be a matter of record.
Lord, it is there at page 30 in the submission, my lord, para 30, my lord. The submission made by SSC in the High Court.
They just read out that. But just we like to answer after they've completed. We like you to answer that.
Lord, para 30.
Para 30 of the written submission.
30 minutes of the impugned lord.
Judgment.
While dealing with their written submissions.
So this is the, my lord, admissions, my lord. They have admitted before the High Court.
Page 106.
Page 106, my lord, para 30, contentions of SSC, my lord. Excellent. Para 30, my lord.
Yes.
Dr. Sutanu Patra, appearing for the School Service Commission, has referred to the 4 affidavits filed it pursuant to the order of this court. Lord, the affidavits, my lord, your lordship can make a note, my lord. They are at page 545 to 553. 545 to 553, 554 to 604,
554
to 604, 605 to 701, and my lord, 701 to 756.
Yes.
But he has drawn the attention of the court to the steps and measures that SSC took subsequent to the discovery of illegalities in the selection process. He has contended that SSC took such steps on the basis of the data supplied by CBI. He has pointed out that SSC had no material to disbelieve the data supplied by CBI. Note, CBI also, my lord, is in an ever-evolving process. They are still in the process. Moreover, SSC has acted pursuant to the orders of the court. Lord, I will not trouble.
No, but this is something different from what is
read out at 242.
What you read out at 242.
Yes, my lord, what at 242, what I read out, my lord, is my lord the conflict between the board, my lord, and
They said that they did not discount the fact that the possibilities of further illegalities exist.
yes, ma'am.
Did they say that in any of those 4 affidavits?
Anyway, please, somebody else will point it out. If they-
Your lordship may kindly, my lord, I'll just read, my lord, para, my lord, 271, my lord. And my lord,
4 affidavits to disclose that they have been varying from time to time. I'll refer to my submission.
my lord, when the illegalities were seen, my lord, the numbers are given 271 and then, my lord, page 229. Justification that has been sought proffered by the board is that all appointment letters are on the basis of the recommendation of SSC. But SSC has contradicted such justification of the board.
Which page are you? Which paragraph?
But para 271, my lord, on the next page, para 229.
Oh, yes, yes.
Justification that has been sought proffered by the board is that all appointment letters are on the basis of recommendation of SSC. But SSC has contradicted such justification on the board by claiming that no such recommendation letters are issued. So between the SSC and the board, my lord, there is open contradiction.
This we have reconciled. In any case, you are beyond recommendation.
And my lord,
We have taken that into consideration in the number we have given of the intent.
Para 271 documents the number of excessive appointments in each category.
There is a reason for that.
After this, you got together and patched it up.
yes. Not zero, none of the. Your lordship may just imagine, my lord. Your lordship may just imagine, my lord, an OMR sheet, my lord, where nothing is written. Just imagine, my lord. And my lord, it is checked, it is recommended by the SSC, my lord, appointed by the board. Just, my lord, and my lord, your lordship may just see, my lord, what they're going. These people are going to impart education to children. Where will, my lord, this country go? No, according to me, my lord, what?
Let's suppose somebody is recommended and he doesn't take the post. Then a second recommendation has to.
You understand that? You don't have,
That is always.
Delhi, you don't have to argue that. Is we understand that part. Delhi, you don't have to argue that. But look, you also realize there is wrongdoing. The question only is wrongdoing is of that level that we can't now separate merit from illegally appointed. So that's all.
At 5 different.
That's you are also in this. You are also helpless. In a way, you are helpless.
Mr. Gupta was
and the board.
Mr. Gupta was kind enough to say, my lord, at the first instance, Mr. Gupta was kind enough to say, my lord, that he can't improve post facto. He can't improve. So then the
Continue, please. It's already good. It's more. We have already crossed about 3:45. Please let him continue.
Duplication is marginal. That's about it. I won't say anything.
Application of arguments.
But para 273, I'll just complete. Your lordship will not have been patient enough to
Okay.
everybody, my lord. But para 273, my lord, after my lord, the infighting between the SSC and the board, my lord, as to my lord, the kettle calling the pot black or vice versa, my lord. But SSC at no stages of hearing claimed that it was able to check all the records and be definite as to the number of illegalities in recommendations made, but had limited itself only to those figures. So they could never check also, my lord. And my lord, that could reflect, my lord, in one of the affidavits, my lord. I had referred to, my lord, 3-4 affidavits. It is at page 650, my lord.
Miscellaneous volume 5B.
Of miscellaneous volume 5B, my lord.
This is a fee.
Paragraphs
Paras at page 650. This is the SSC's affidavit, my lord. Hopefully in black and white. May I read, my lord? Para 6, my lord. However, I say that there may be more candidates who were wrongly recommended for appointment by the commission, for which I most humbly pray for some more time to further verify the records of the commission and to produce the list of such
Date
candidates.
of this affidavit.
Lord, I'll just give it in.
This is affidavit.
This is the third affidavit, my lord. Third?
September 22.
Date of it?
September 22.
22nd September 22.
22nd, my lord.
September 2022.
22.
20th September.
This is the third affidavit.
Number identified so far.
Number identified so far.
It's 315.
So, my lord, there is no definite number, my lord, as to the number of illegalities committed. They are all hunting in the dark. No, your chart is worthless, my lord.
Sir, page 315 identified so far. Page 315.
Okay, yes.
My lord, there's another chart, my lord, my learned friend here, my lord, prompts me to, my lord, request your lordship to kindly see, my lord, at page 3154, my lord, of the same volume 5B, my lord. Ours is volume 5B, my lord.
3154.
My lord.
Yes.
Identified so far. It is before the division basis.
My lord, where class 9, 10 is mentioned, my lord, it says, my lord, number identified so far. Well, Mr. Bhattacharya, my lord, has placed that. Now, my lord, if your lordship may kindly see, my lord, the stand, my lord, of the learned advocate also before the High Court, my lord. I should not be reading this, but in fact, if your lordship may kindly see, my lord, para 268, my lord. Your lordship may read it.
Yes.
Lord, para 268, my lord. This course of action has been adopted by the state. Your lordship have that, my lord?
Yes.
In order to prevent discovery of further manipulations, illegalities in the selection process, if possible. And now very important, my lord. The SSC, the board and the state government have consistently stonewalled any queries with regard to the selection process and have not come clean with regard to the manipulations, illegalities involved. The conduct of the three authorities during the course of hearing can be classified as anything other than being cooperative. Milord, there are other words will not use, Milord, for the advocates appearing, Milord. I don't, Milord, want to wish to highlight it, Milord, but just suffice it to say, Milord, that there is a three-pronged attack, Milord, on candidates, Milord, who had good marks, Milord, who could have, Milord, been good teachers. But, Milord, because of this monetary consideration, Milord, today, Milord, I'm given to understand, Milord, that the minister is still in jail about 2 years' time, Milord. 50 crores found, Milord. I don't want to, Milord, put the criminality into it, Milord. But, Milord, the level to this, the level, Milord, to which these three authorities, Milord, have fallen, Milord, to ensure that the education system, Milord, somehow is, Milord, affected, but my pockets are full. And this is, Milord, the basic feature, Milord, in this large, as Mr. Bhattacharya said, Milord, institutional criminal conspiracy, Milord. And, Milord, I would say, Milord, one thing, Milord, if your lordships are, Milord, with us, Milord, then there are, Milord, there is a direction passed, Milord, for return of some monies, Milord, for those people who somehow taught within inverted commas. My, Milord, prayer and request to your lordship would be, Milord, to make this as an example, Milord, and, Milord, fix the three authorities with such cost, Milord, so that this never happens again, Milord. It should be, Milord, I think, Milord, at least 500 crores for each of them. It would be, Milord, if you make a calculation, Milord, I was there, Milord, about 7 to 10 lakh rupees each candidate has paid. is, my lord, what is in the corridors, and the grapevine, my lord, has got enough effect.
So, yes, next.
What Mr. Rahim has said, para 329 also worship will not.
Understood.
I mean 103, which is the culmination of what Mr. Rahim has argued. 329 is the conclusion. And that's where they say it cannot be segregated. And that's why cancellation of the entire selection.
Lordships, I'm appearing for the people who are saying that it can be segregated, and I'll just explain to your Lordship.
You are appearing for?
The people who are saying that it can be segregated.
No, you should have come on this side.
What we said. This is what we said. She should
I'm
come
on
that
this
side.
side because I'm not selected, your Lordships. I would.
No, we were very clear. We were very clear, you should have come on that side.
The reason is this, that I am.
So please, just wait for your turn, let others conclude.
May I just read this para 329 and that's what
we have already marked that paragraph.
Great. This is the entire conclusion that why this selection, this cannot be segregated.
Anybody else?
Therefore, it should be cancelled.
But Mr. Ghoshal was there on the other side, not that time. So I would respectfully say, request him to be on that side again.
Anyone else supporting Mr. Rahim and Mr. Bhattacharya?
You can't be on that side and then here.
Anyone else supporting both of you?
I would
Only two of you then.
may I only send to stage since
if Mr. Vikram or Mr. Firdaus wants to add a line, they are youngsters, I told them that this court would hear everybody.
I don't want to add something.
Just want to place one thing. The School Service Commission and the state must come up with a definite stand. And before the High Court, they have not come with a definite stand how as to the number of illegalities. Even then, courts of hearing, my lord, one after another affidavits came up, but the stand of the state as to the definite number of illegalities, neither the state nor the School Service Commission could submit before the court. And what I want to respectfully submit, your lordship, is that whether illegalities would exist in future or not, after the identified numbers. In that event also, my lord, the chairman of the School Service Commission is physically present. He also cannot say throughout the entire selection process whether further number would come out or not. He is personally present before this court. With this, my lord, I end my submissions. Thank you.
My lord, I am supporting Mr. Rahim and Mr. Bhattacharya, my lord, only on the 4 affidavits that have been filed before the division bench, my lord. The first affidavit, there was a full bench decision of the School Service Commission. After the first affidavit, the second affidavit came saying that the first affidavit is not exhaustive. They gave a list that these are the number of illegalities, where, my lord, certain illegalities were not given. Third affidavit, they say, my lord, it has been already placed that identified so far. And the fourth affidavit, my lord, which has also been placed before your lordship, states that in clarification of the third affidavit, we found that these are. So till date, the division bench gave them chance to file 4 affidavits. SSC is not clear what is the figure, exact figure of illegalities, because, my lord, kindly one thing, since there are 100 vacancies and 150 candidates have been appointed, my lord. So who are those extra 50%? SSC cannot identify. My lord, admittedly, 100 recommendations, 200 appointments, and they are saying that we did not issue. And this has come from BAG, Justice BAG committee reports also. Those persons are not identified. And interestingly, my lord, if your lordship sees the written submission of SSC filed before your lordships, they have not said, they have not given the figure who have been appointed after more than vacancies and more than recommendations. Only because these cannot be segregated and these cannot be identified. And other, my lord, I adopt the submissions of Mr. Bhattacharya. Wait.
In addition of submission made by my learned senior friend, my lord, but I just give the impression which my learned friend time and again says that we gave the figure before this court. My lord, kindly take the final compilation volume 6, which is in written submission given by the School Service Commission, page 16 and page 17. The figure which is given by the School Service Commission before this, sorry.
Yes.
The figure which is given by the School Service Commission in this tabular chart, and if we add these 3, that is rank jump, out of panel and OMR sheet issue, the number came out 5,485. And the my lord will remember the last occasion on behalf of the board, one tabular chart handed over, which is this, my lord. And if we add this number, so that come out 5,189. even the document which is placed before this court, there is also mismatch between these two Article 12 authority. Apart from that, my lord, the expiry of the panel, which is evident from this tabular chart, that is out of panel and expiry of the panel. Kindly turn, my lord, volume 5B, page number 2966. A tabular chart which is given where, my lord, it is evident the publication of final vacancy dated 11 September 2017. And according to the rule 15 of 2016 rule 15 is page number 959. May I read the rule 15?
Yes.
Rule 15 says validity of panel and waiting list. May I read?
Yes.
Each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list or the date of advertisement for the next selection test, whichever is earlier, provided that the names of the candidates shall not be recommended against any post other than the post applied for or against any vacancy which has not been notified in terms of clause B of sub-rule 3 of rule 8. So it is evident from this rule, validity of panel is 1 year. Kindly see, turn page number 2966. The second 2966 of volume 5, 5B, 2966. Very interesting, my lord. Date of publication of result is 11 September 2017. So panel validity lost on 11 September 2018. Kindly see, my lord, date of counseling. First date of counseling is 16 July 2018 to 22nd July 2018. Second round of counseling 29th August 2018 within the validity period of the panel. The next counseling, third counseling, after expiry of the panel. Fourth counseling, after expiry of the panel. Fifth counseling, after expiry of the panel. Sixth counseling, after expiry of the panel. So, every counseling hold after second round of counseling, it is regarding 11-12. My lord, kindly see the 910, page number 309, 3009, a tabular chart which is evident that date of publication of final panel 12 March 2018. So, the panel validity expired on 12 March 2019. Kindly see the date of first counseling, 12 March 2018. Then second counseling, 3 February 2019. Then third counseling, after expiry of the panel. Fourth counseling, after expiry of the panel. That's to up to 8th counseling. So, in their affidavit, they says only 8th counseling is after expiry of the panel. But rule says, from third counseling onwards, every counseling after expiry of the panel. That's my humble submission, my lord. So, my lord, whole selection process, the submission, which is done before this court as well as the written submission.
Counseling, because personality is personality.
May I, my lord, place the rule. Rule is that, my lord. First, this selection process is 100 marks selection process. Out of the 100 marks, 55 marks for written examination, 35 marks for academic excellence and professional qualification, and 10 marks for the interview. After 55 marks evaluation, they ought to publish a list that called interview list. They publish the interview list in accordance with law. Rules is that very specific. My learned senior friend placed the rule. Rule is that they ought to publish the marks with breakage of marks. In the year 2018, they not published the marks. They gave the one-to-one communication, which my learned senior friend says.
So probably they publish a list without the marks.
Yes, my lord. Without a mark, and that too, my lord, that too not in interview list, because in the rules there are 3 type of list. May I place this rule if my lord's one? If my lord not one, I place it because the whole rule is, my lord.
12-6. 12-6.
12-6. May I place the rule, my lord?
Rule
2 is the definition section. There are 4 type of list. 2F says about interview list. 2F. May I read the page number 955. 2F says about merit list. interview list. Interview list means a list of candidates to be called for personality test, category-wise on the basis of merit, marks of written examination, academic and professional qualification, in the ratio of 1:1.4 of final vacancies. Suppose there is 100 vacancies, so they ought to publish 140 candidates' marks with all details as an interview list, but they're not published it. It is pre-interview, and after interview, there is a list that called merit list. That merit list definition is also in the rule. Kindly take the definition of merit list 2G. 2G says merit list means a list of candidates prepared category-wise on the basis of marks obtained by a candidate in written test, in academic and professional qualification, and in the personality test. But in the year 2018, they not published this merit list in accordance with rules. We came before this court in the year 2021, when we came to know about that candidate, some candidate who are the less meritorious candidate, whose number is, whose merit position is less, because number is, at that point of time, number was not published. Number published in the year 2022, when the court gave that direction. In the initial year, in the year 2018, they not publish the even interview list. They only give one-to-one communication to a particular candidate.
Interview list is properly published. We just get a clarification from them. They're saying interview list was published. It was not 1:1. And then they published the final list, pursuant to which probably when appointment letters were issued, some people got into it, and they then filed that why is marks list not been published. So then the mark list got published. When the mark list got published, then the whole thing blew up.
With the best of respect, that is not the position. Position is that there are 4 types of list. One is interview list, another one is merit list, another one is panel, and another one is waiting list. Suppose pre-interview, they ought to publish a list that's called interview list.
We have understood that. We have understood that.
Post-interview, merit list. And from that merit list, 2 types of list will be there. One is panel, another one is waiting list. So they ought to publish 4 lists. But instead of that, they publish 3 lists. And it will be grateful for patience hearing, my lord.
Well, next Monday, my lord, there's a holiday, my lord, in Vasant Panchami, so we will all be having.
No, we will not be probably.
Can it be on 4th, my lord? Can it be on 4th, my lord?
It's not a holiday.
It's not a holiday. It's in Calcutta.
It's in Calcutta, all of us, because I have to make certain submissions, my lord. We have puja at our chamber because Saraswati Ma, like, can it be on 4th, my lord? Only, well, can it be on 4th? 1 day's accommodation, my lord, we are seeking, my lord.
Then it'll go to next week. Beyond that. No, Friday we are not seeking. 10th. And 10th we are going to conclude whatever way we want to.
Keep it on Monday.
Keep it.
Councils who are here, we can finish your lordships.
Friday may not be possible.
Your lordships Monday, your lordships is.
Lordship, can it be on 4th? Well, that's
No problem.
difficult.
Just see, we can't help it. We'll keep it on 10th.
Councils who have
10th.
argue. You can argue.
10th to okay. Yes, please.
My lord, sir, last time I had mentioned the transposition application, and my learned friend had said he wants to examine it. It's fairly uncontroversial. I was an appellant in the High Court. This man just didn't have the resources to file a petition.
Whatever.
He's a legal aid candidate. Can he just be transposed? My lord, I hand up the IA number.
Very bad practice way from him.
He was.
10, 2 p.m.